What's up, guys? Brian Fellow Law Group PLLC here with your Florida Law Weekly case update. I got three cases for you this week, one of which is a super important case for appellate attorney's fees in paternity cases, so stay tuned for that one. First one I got is O'Brien versus O'Brien. It's out of the 4th DCA. I like to chalk this case up to saying basically he got away with it. All right, former husband totally got away with one here. So what happened in this one? Basically, it's a divorce case. In the divorce, former husband was ordered to pay alimony to his former wife based on the fact that he was living in his mother's house. So his mom owned the house that he was living in. Therefore, he didn't have a mortgage to pay. He didn't have to pay certain expenses associated with the home in which he was living. So what happens? I'm not sure exactly how long, but let's say a few years later, his mom sells the house that the former husband was living in, and then the former husband goes and buys a new house and gets a mortgage, essentially gives a mortgage on his new house to his mom because his mom loaned him the money to buy his new house. You get it? So basically, mom owns a house where former husband is living. Mom sells that house, uses the proceeds of the sale of that house to buy former husband a new house. So it's kind of like the same thing. It's just, he got an upgrade, right? So now former husband says, wait a minute, I have to pay a mortgage to my mom. So I no longer have the ability to pay my alimony. Can you believe that? Well, apparently the court did and said, hey, no big deal. You former husband, you proved your case. You no longer have the same expenses. Your expenses have gone up. You got to pay your mortgage. You got to pay certain expenses associated with your new residence. And so therefore you no longer have the ability to pay the alimony. Another issue was former husband now had a live-in girlfriend apparently, and the live-in girlfriend wasn't contributing anything towards the expenses. So of course the former wife said, well, judge, you should attribute some in-kind, payments or something to the husband for the girlfriend who's not contributing anything. And the court said, no, actually, you don't have to do that because it's not like a supportive relationship situation where the payee is the one in a supportive relationship, and therefore the court has to take into consideration the support that that person's boyfriend or girlfriend is paying. But in this case, it's the payor, so the court really doesn't have to take that into consideration unless the live-in girlfriend actually was contributing to the expenses of the household. Then the court would have to take those payments into consideration. But because it is the payor and the girlfriend apparently really wasn't paying anything on behalf of the house and didn't have to because the former husband was required to pay his mortgage anyway. So it didn't really matter if the girlfriend lived there or not. But again, I think this is one where he totally got away with it. I mean, it's the same thing. He's living in a house that's really owned by his mom. And the new case in the new house, he's got a mortgage with his mom, right? So I don't know. I think he totally got away with one. Notably, the former husband was the only person to testify at this hearing. I don't really know why. But anyway, next case is out of this new 6th DCA. I don't know if you can still call it new. But anyway, this is a super, super important case for paternity proceedings. Court basically said in paternity cases, you cannot get appellate attorney's fees based on need and ability to pay. So we all know 6116, need and ability to pay in family law cases, specifically includes the language, and this includes appeals. Well, the corresponding statute for the paternity case, which is 742.045, does not include that language that says and including appeals. Has very similar language. It's all the same type of thing. I think it's meant to do the exact same thing, which is provide attorney's fees for a person, a mom or a dad in a paternity case that doesn't have the ability to pay for their own fees. It's sort of like a balancing inequity fee shifting provision that allows each party the ability to obtain appellate counsel, right? But the language in the paternity statute does not include appellate attorney's fees. Well, that used to be the ruling of the 4th DCA and the 5th DCA. They actually originally said, well, because the statutes are so similar and the paternity statute does not include the language regarding appellate fees, the 4th and 5th DCAs used to say, well, no attorney's fees in paternity appeals. Then the 4th and 5th DCA retracted from that and said, well, the language of 742.045 is basically so broad that it includes any proceeding and any proceeding ostensibly includes appeals. Therefore, 742.045 also includes appeals. So that was the law for a few years, since like 2017, 2018. Well, now comes this new case. This is I guess it must involve minors or somebody that's going through a dependency proceeding, because it's CS versus TG. It's the initials. And it's a paternity case, and basically, court said, nope, 4th DCA, 5th DCA, you got it wrong. Actually, if the language of 742.045 really does not say any proceeding, or it doesn't apply to appeals, because any proceeding in the context of 742.045 really means anything under that chapter that's in 742, anything under 742 basically. But 742 does not mention appeals anywhere, no mention of appeals whatsoever, so it does not apply. It's basically, they're saying that an appeal would be in a proceeding under the appellate statutes, under the appellate rules of procedure. It's not in a proceedings under the paternity statutes, so therefore there's no fees under 742.045. Very interesting case, certified conflict, probably going to get decided by the Florida Supreme Court. But for now, if you're in the 6th DCA, you can't really get appellate fees if you're appealing a paternity case. Not a good thing. So be aware of that. Next case is out of the 3rd DCA, and this is sort of another attorney's fees case, a little simpler issue, but basically people always get this wrong. 61.16 does not allow fees for the spouse that has a greater ability to pay. Even though if you're trying to get fees, it's saying, oh, the spouse engaged in vexatious litigation, they were filing all these things that they didn't need to do, extended litigation, judge, you should award me fees because I had to incur all these superfluous attorney's fees for all these motions that my spouse is filing. Well, the court once again said, no, under 61.16, it's still primarily based on need and ability to pay. It's finances. It's financial need and financial ability to pay. And then the court can reduce that amount if another spouse engages in vexatious litigation, things like that under Rosen. But if you're traveling, and the court can also award fees under inherent authority for vexatious litigation. But if you're traveling under 61.16, it's need and ability to pay. So you really have to plead and prove need and ability to pay if you're traveling under 61.16. All right, guys, that's it for this week. Hope you enjoyed it. I'll see y'all next time.